All right, let's be on the record in case number 2020 CR 57, captioned State of Kansas versus Maria Purgue. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
May it please the court, Ms. Purgue appears on video with counsel Courtney Henderson.
All right, we're here set down for a plea hearing today. Ms. Purgue, my understanding is you know that if you wanted to be personally in court, we could set that up at another time. But in talking with Mr. Henderson, my understanding is you're willing to waive your personal appearance in court today and do this electronically. Is that correct?
Yes.
Okay. All right. As I said, we are here set down for a plea. In order to take up your plea, I have to ask you some questions. To do that, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
All right. Now, Ms. Purgue, if I ask you a question during this that you don't understand, make sure you tell me that, and you and I will talk about it until we make sure that you understand the question you're being asked before you answer it, okay?
All right.
All right. And if any time before answering a question, you want to talk to Mr. Henderson in private, I have the capability of doing that. In other words, I can let you and him have a conversation that the rest of us can't hear. So you just tell me if you need to do that and we'll make it happen, okay?
All right.
All right. Ms. Purgue, how far did you go in school?
I have master's degree in education.
Okay. So I assume you can read and write English, okay?
Yes, I do.
Okay. Now, again, English is not your first language. Is that correct?
Spanish.
Okay. So anytime, again, if you don't understand something, I need you to let me know and not just take a guess at what I'm asking, okay?
I will.
All right. Now, do you understand what you've been charged with?
Yes.
Okay. As you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what we're doing today?
No.
Feel like your mind is clear?
It is.
Okay. You understand you don't have to change your plea from one of not guilty to guilty. If you wanted a jury trial on these charges, you would have a right to that trial. Do you understand that?
Yes.
Okay. At that trial, Mr. Henderson would be able to assist you. He would confront and cross-examine all of the state's witnesses and evidence, and he could call any witnesses you wanted called. Do you understand that?
Yes, I do.
All right. At that trial, you would have a right to testify, but you would also have the right not to testify. And if you decided not to take the stand, the state couldn't use that against you to argue you must be guilty for not testifying. Do you understand that?
Yes, I do.
All right. Now, at the end of that trial, if there was a conviction, you would have a right to appeal that conviction to an appellate court. And if you didn't have the money to pay for that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if we go forward with this plea today, there's not going to be any kind of trial like that either before a court or a jury, and you'll be giving up all those rights I just talked about. Do you understand that?
I understand.
Okay. And also, before coming on the record, we talked about the need to waive a preliminary hearing. You would have a right in this charge, if you were not wishing to plead guilty, to have also what's called a preliminary hearing. That's a hearing before trial in which the state would have to put on enough evidence to prove to a judge that there was probable cause to believe that a crime had occurred and that you were the person who committed that. My understanding is you've talked to Mr. Henderson about that and you wish to waive that right today. Is that correct?
Correct.
All right. And Mr. Henderson, also on behalf of your client, do you waive preliminary hearing?
Yes, Your Honor.
All right. And Ms. Whitman, on behalf of the state?
State waives as well, Judge.
All right. I'll find both parties have waived preliminary hearing. There is probable cause for this crime. The defendant will be bound over for trial. I will enter a plea of not guilty at this time, although we're going forward with a guilty plea. All right. Ms. Purgue, Mr. Henderson's been your attorney throughout this case. Are you satisfied with his advice and counsel?
Yes, I do now.
Okay. You think you've had plenty of time to talk to him about the case and he knows everything about the state's evidence and any defenses you might have?
Yes,
Okay. Now, I'm told that we have the a plea agreement in which you'll be pleading guilty to DUI a third time. Well, let me stop myself right there. Miss Whitman, would you inform the court what your understanding of the plea agreement is?
Yes, Judge. The defendant will plead to count 1 DUI as a third offense. The sentence will be 1 year in jail, suspend all but 90 days. The defendant will be placed on 1 year post-imprisonment supervision, pay costs, the fine of $17.50. She must attend a MAD impact panel within 60 days of release. She must get an evaluation and follow the recommendations. She cannot drive unless properly licensed and insured. If she does drive, she must have ignition interlock in her vehicle. If she's caught driving without the device, the state will look at this as a prima facie violation of her probation. She cannot take illegal drugs. If on any prescription medications or over the counter, she must inform her supervising officer.
All right. Is there an agreement as to whether those 90 days need to be served in jail or whether she's eligible for house arrest or work release?
I did not put any parameters on how she would serve the 90 days in our agreement.
All right. Mr. Henderson, is that your understanding of the entire agreement?
It is, Your Honor, and as I've explained to my client, we would be asking for a combination of in custody and house arrest time, and she is aware that we would be asking for that as part of the 90 days.
Okay. All right. Ms. Pruge, did you hear what the prosecutor and your attorney said the plea agreement was?
yes, yes, Your
Is
Honor.
that your understanding of the entire plea agreement?
Yes,
Okay. Has anybody else promised you anything else to get you to plead guilty today?
no,
All right. Has anybody threatened you or placed force against you to make you plead guilty today?
no,
Okay. In that recitation of the plea agreement, there were a number of things about what the party's going to recommend to the court as to sentencing. Do you understand? I'm going to listen closely to everybody's recommendations, but legally, I'm not bound by any of their recommendations, and I can give you any sentence that the law allows. Do you understand that?
yes, I do.
The maximum sentence in this case is up to 1 year in jail and a fine of $2,500. Do you understand that those are the maximum sentences in this case?
Yes, I do.
All right. Do you have any questions for me whatsoever about anything that we've gone over this morning?
No,
Okay. Mr. Henderson, do you know any legal reason why your client should not plead today?
I do not.
All right. Then I would ask you, Ms. Pruge, as to the 1 count of DUI, third time, a non-grid felony, how do you plead, guilty or not guilty?
guilty.
All right. I'm going to ask Ms. Whitman to tell me what she thinks the evidence would be if we had a trial in this case. I want you to listen closely because when she's done, I'm going to ask you if that's what happened, okay?
Right. Okay,
Ms. Whitman.
Yes, Judge, on or about February 21st, 2019, officers were dispatched to 7th Street Casino in reference to an intoxicated person. Security there indicated there was a very intoxicated white female. She was having trouble walking. They attempted to get her a cab, but she refused and attempted to get into her own vehicle. Security brought her back into the casino to wait for the police. Once the police arrived, they could detect a very strong odor of alcoholic beverage coming from her person. They identified her as Maria Purgue. She was very hard to understand. She had bloodshot, watery eyes. Her speech was slurred. Officers observed her leaving the casino and walking to her vehicle. They advised her not to do that, not to get in her vehicle. She then got in her vehicle, started the vehicle, and they stopped her. She was asked to perform some field sobriety tests. Those tests indicated impairment. She was read the advisories and asked to take a breath test, and she refused to take the breath test. After review of her driving record, it was determined she had at least 2 prior convictions for DUI, a diversion out of Overland Park in January of 2005, and a second one in Merriam in 2016. All these events occurred in Wyandotte County, Kansas.
All right. Ms. Pruge, did you hear what the prosecutor just said?
Yes. I
Is that
did.
what happened in this case?
Yes.
Mr.
It is.
Henderson, is that your understanding of what the state's evidence would be in this case?
Yes, Your Honor.
Alrighty, thank you. I will find that the defendant has freely, voluntarily, and intelligently changed her plea from one of not guilty to guilty. She understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find that the defendant is guilty as charged of DUI, third conviction, a non-grid felony. I'm going to order that a pre-sentence investigation be conducted, and we will continue sentencing pending the receipt of that. Mr. Henderson, Ms. Whitman, my intent is to try and set this on a Friday morning, say mid-September. Will that be sufficient to get the evaluations that we'll need to go forward with sentencing?
Well, the actual her alcohol evaluation is done through the probation. She doesn't have to have that prior to sentencing.
Okay, all right.
So all we need is the PSI in this matter. And I will state for the court, on Fridays are the worst days for me, Judge. I'm just booked solid on Fridays.
Okay, we usually do Fridays for sentencings, but with Ms. Whitman and the traffic docket, we make exceptions to that. So let me take a look for a date to give you here. My September actually looks pretty good at this point. I try and do, Mr. Henderson, I would ask, do you or your client have any objection to doing the sentencing in the same manner we're doing today by video conference?
No, Your Honor. I think that would be preferable. As I had informed Ms. Whitman yesterday, my client has recently traveled to the state of New Jersey for her father's funeral. And so certainly with travel restrictions and some of those concerns, I think remaining on the video appearances is to everyone's benefit.
Okay, so I'm looking at September 16th, which is a Wednesday morning. I could do 9 a.m. that morning. Would that work for you, Mr. Henderson?
I am available.
And Ms. Whitman?
At what time, Judge?
9 a.m.?
I have a bench trial in Division 12.
Okay. Do you have an idea how long, if I did 11 o'clock that morning?
That would work. Yes.
Okay. Mr. Henderson, 11 o'clock on September 16th?
That would be great. Thank you, Judge.
Okay, that's when I'm going to set sentencing. Mr. Henderson, I don't suppose that you have a copy of my PSI request, do you?
I do not.
Okay, when we're done here, I'm going to email you a copy of it. Basically, what it is a document that gives your client's contact information. We then provide it to probation, and they reach out to her to set up her pre-sentence interviews and things she needs to get done. So I'll email that to you as soon as we adjourn here today. And on that note, is there anything else that anybody wants to take up before we adjourn?
I know of nothing else, Judge.
No, Your Honor.
All right, Ms. Pruge, good luck to you. Here's what's going to happen. I'm going to get your attorney a document that basically he will be returning to our probation office with your contact information. They will then reach out to you to set up the different interviews and things you need to do to be ready for our sentencing come September 16th at 11 a.m., okay?
That's fine, Ohana.
Great. Okay. If there's nothing else, we are adjourned. Thank you, everybody.
Thank
Have
you.
a great day.
Thank you.
Thanks.